On behalf of the e-board and the whole team, we really want to congratulate the 4 finalists this year. We have Julie Johnson, Whitney Johnson, Rhea Dorman, and Nyla Lamb. We're really proud of them, so thank you all for showing your support. To start the competition, each student wrote a memorial advocating for their respective sides. For the first round, students were given 10 minutes to argue both issues, and then from there we got our 8 semifinalists. For the second round, we then asked 3 professors to judge to get the 4 finalists, and here we are today. The finalists will be arguing for either the applicant, the Republic of Anne Melania, or the state of Romanovia, the respondent. To give a brief overview of the case, the state of Pella was dissolved into 2 states, Anne Melania and Romanovia. The border of these 2 parties runs through the territory called the Elysium. In this territory, there is an Elysian traditional custom requiring the mavazi headscarf to be worn by all females. The mavazi was used to conceal an identity of a suicide bomber, killing hundreds and damaging buildings. The issues before the court will be 1, whether the court has jurisdiction over the claim, and 2, whether the ban of the mavazi violates international law. After the oral arguments, the judges will deliberate, and we will then present the Best Memorial Award as well as the Best Advocate Award for the inter-school competition this year. So thank you again for coming, and we will now have the judges come in.
All rise. The International Court of Justice is now in session. President Tellman, the Honorable Judges Aaron, Knowles, Stallbrink, and Voss presiding. The case before the court is a matter concerning the ban of the mavazi for Malaysian women and girls. The parties are applicant, the Republic of Anne Melania, versus respondent, the state of Romanovia. The applicant and respondent are each allocated 20 minutes to present their pleadings.
Good evening, Mr. President and Your Excellencies. May it please the court. My name is Julie Johnson, and I represent the applicant in this matter, the Republic of Anne Melania. I will begin this evening by addressing the first issue, that Anne Melania does have standing to bring its claim before this court, as it has accepted this court's compulsory jurisdiction as a successor state to the Republic of Paula, and that it has standing to bring this specific claim before this court as on behalf of diplomatic protection of the Elysian people. My co-agent, Rhea Dorman, will then address the second issue, that the Romanovian ban on the mavazi head covering is in violation of international law. At this time, would Your Excellencies like a brief recitation of the facts?
Sounds like we do.
Thank you, Your Excellencies. First, Anne Melania does have standing to bring its claim before this court because it has accepted the compulsory jurisdiction of this court as a successor state to Paula in the United Nations. Anne Melania's behavior, as well as that of the UN and its member states, demonstrates that Anne Melania has been accepted as a successor state to Paula in the United Nations and its organs. Pursuant to the Vienna Convention on the Law of Succession of States in Respective Treaties, Article 2, the succession of states is defined as the replacement of one state by another in the international relations of a territory. A predecessor state does not simply disappear, but rather...
Can you tell me what gives Anne Melania standing to raise the substantive claim on behalf of these women, who, my understanding, you can correct me, is they don't all live within the borders of your country. So what gives you standing to represent them?
Your Excellency, that is correct. Elysians enjoy dual citizenship in both Romanovia and Anne Melania. However, Anne Melania has standing to bring this claim on behalf of diplomatic protection of the Elysian people because Anne Melania is suffering harm from having all of the Elysians seek asylum in effectively forced out of Romanovia, and because Elysians have no local remedies in Romanovia because they face a great risk of prejudice and bias.
When did you bring a claim, a substantive claim for something like forcing the departure of these women or these people from their home country? Why not raise a claim for ethnic cleansing or something like that? Why focus on the headscarves, that issue?
Your Excellency, Anne Boleyn is focusing on this issue specifically because Romanovia has violated many treaties and conventions to which it is a party that the Mavazi ban is a violation of the fundamental freedoms of the Elysians. So Anne Boleyn is bringing this claim on behalf of the Elysians so that their fundamental freedoms can be restored. Every state, by virtue of its membership in the international community, has a legal interest in the protection of certain basic rights and the fulfillment of certain essential obligations. The international responsibility of states is not only limited to the state itself, but may also extend to other states and other international organizations. Diplomatic protection is the invocation of a state, through diplomatic action or peaceful means, of the responsibility of another state for an internationally wrongful act of the wrongdoing state. The state entitled to exercise diplomatic protection is the state of nationality. Romanovia will rely on Article 14 of the Draft Articles of Diplomatic Protection, which states that a state may not bring a claim on behalf of its nationals when the internationals have failed to exhaust all local remedies.
Is it your contention that these draft articles are codifying customary international law because they have not ripened into the status of the treaty? Obviously, they're draft articles, or are they customary international law?
Your Excellency, they can be considered either customary international law or a general principle of law. However, Article 15 of the Draft Articles of Diplomatic Protection provide exceptions to the local remedies rule. One of these exceptions being when there are no reasonably available means of redress or the local remedies provide no reasonable possibility of effective redress. Elysians enjoy dual citizenship in both Angulania and Romanovia, and they have occupied this territory since prehistory. Romanovia.
Backing up a bit, I got distracted by my colleague's questions and let you slide through your argument that you are a successor state to Paula. Who has recognized you as a successor state?
Mr. President, the behavior of the UN and its member states demonstrates an acceptance of of Anne Boleyn as a successor state to Paula in the United Nations. When Anne Boleyn wrote its letter to the Secretary General stating that it wished to continue Paula's membership in the United Nations, it asked that its nameplate and flag replace those of Paula in the United Nations, which the UN did.
It seemed like only symbolic measures. What about the actual statements by the Security Council and the statements by the Council to the General Secretary? Isn't there some conflict? Can you tell us why we should give one precedence over the other?
Your Excellency, Resolution 2386 and the Undersecretary General's interpretation of 2386 were issued in 2001. Since that time, 12 years later, Anne Boleyn has still been an active participant in the General Assembly and in the United Nations itself. Further, Resolution 2386 said that Anne Boleyn should apply for membership in its own right. It did not use absolute language, and then the Secretary General asked the Undersecretary General to issue his interpretation in which he stated that Anne Boleyn could temporarily continue the membership of Paula in the United Nations. Romanovia and a few other states were the only members of the General Assembly to contest that interpretation.
Is it your position that the Undersecretary of Legal Affairs can override the Security Council?
Your Excellency, no it is not. However, Anne Boleyn does not wish to downplay the importance of the Security Council's resolutions or the Undersecretary General's interpretations of those resolutions. However, Anne Boleyn asked that this court focus on the behavior of the UN and its member states since the resolution and its interpretation have been issued.
So you're contending that you have membership by adverse possession?
Yes, Your Excellency, you could say that. The UN and its member states have acquiesced in Andalusia as a member of the United Nations, and therefore Andalusia does not have to apply in its own right, as was the successor state to Paula in the United Nations.
Is there authority supporting this principle of acquiescence?
Your Excellency, in Nicaragua versus the United States, although Nicaragua had never ratified its instrument of ratification to the compulsory jurisdiction of the court, the ICJ held that Nicaragua had technically been under the compulsory jurisdiction of the court for the entire 40 years that it had acted as if it was a member of the jurisdiction of the court, even though all states in the UN knew that Nicaragua was technically not under the compulsory jurisdiction of the court.
So I suppose the concern would be that, and I don't know that acquiescence, you have to argue acquiescence, because I thought the ruling of the Undersecretary General was that you were provisionally a successor to Paula. And that's enough for you as far as participation in the General Assembly, et cetera, is concerned. But bringing the case before the ICJ, before this body, is a little bit different, because the concern is that you might be doing so opportunistically, and were the shoe on the other foot, you might then say, but Paula's declaration accepting the compulsory jurisdiction of this body doesn't apply to us.
Mr. President, when Andalusia wrote its note to the Secretary General, it wished to assume all of Paula's rights and duties in the United Nations. It has assumed Paula's multi-year repayment plan of its 1999 dues to the United Nations, and has fully shown that it wishes to be a member of the UN and to be under the compulsory jurisdiction of this court.
But I suppose the obvious question is, given the Security Council resolution, why haven't you sought membership in the United Nations as Andalusia, as respondent Democrat?
Mr. President, Andalusia, viewing a totality of the circumstances, feels that it has been accepted as a member of the United Nations in the behavior of the UN and its member states. The UN complied with all of Andalusia's requests that it stated in its letter to the Secretary General, and thereby Andalusia believes that the way the UN has treated and viewed Andalusia is that it is the successor state to Paula in the UN. Further, there is no evidence in the compromise to suggest that Andalusia may not at some point apply for membership in its own right. However, with this application by Andalusia contends that it is the successor state to Paula in the United Nations.
Say we disagree with you and rule otherwise, is there another way that you can bring this claim or seek this protection?
Your Excellency, I see that my time has expired. May I please answer your question and then conclude? Your Excellency, could you please repeat the question?
Say that we disagree and don't believe that you're a successor state of Paula. What other way can you seek or bring this claim?
Your Excellency, Andalusia is bringing this claim on behalf of diplomatic protection of the Elysian people. If Andalusia was found not to have succeeded to Paula in the United Nations, it would then have to apply for membership in its own right, and then would again bring this claim on behalf of the Elysian people, as the Elysians are its own citizens, and it finds that their rights are very important. In conclusion, Andalusia respectfully requests this court find that it does have standing to bring this claim, as it is the successor to Paula in the United Nations under the court's compulsory jurisdiction and on behalf of diplomatic protection of the Elysian people. I will now yield the floor to my co-agent, Rhea Torman. Thank you, Your Excellencies. May it please the court. Good evening, Mr. President, Your Excellencies. My name is Rhea Torman, and I also represent the applicant, the Republic of Andalusia. The second issue before the court this evening is Romanovia's violation of international law. The ban prohibiting the wearing of the mabazi in public places and while receiving public services violates international law in 3 ways. First, the ban unnecessarily limits the Elysian people's religious and cultural cultural freedoms. Second, it unjustly discriminates against Elysian women. And third, it deprives the Elysian children of the right to enjoy their culture and to practice their religion. The Mavazi ban violates international law because its limitations on religious freedoms are not necessary in a democratic society, and the measures taken by Romanovia were not proportionate to the goals they were pursuing.
Can you distinguish this case for me from the Dalla v. Switzerland case from the European Court of Human Rights? Because it seems that that is precedent that you need to successfully distinguish in order to prevail.
Yes, Your Excellency. In the Dalla v. Switzerland case, the court determined that the restrictions on their religious freedoms were necessary because it was proportionate to the goal of secularism. It's likewise in the Sahin versus Turkey case, where the court determined that restrictions on religious freedom are only entitled if they are prescribed by law, if they pursue a legitimate aim, and they are necessary in a democratic society, such as being aimed at protecting the public safety.
So do you concede that the first two are satisfied here?
No, Your
You concede that it was democratically enacted, this law?
Yes, Your Excellency.
Okay, so that's number one. What about number two?
Your Excellency, Amlania contends that Romanovia did not satisfy the second factor when they passed the Mavazi ban. President Bhutai passed the Mavazi ban he did not pass the Mavazi ban to promote public safety because he began pushing the ban through Parliament prior to the major attacks in Romanovia by the ZDP. Furthermore, if the ban was aimed at increasing public safety, it would not prohibit the wearing of the Mavazi exclusively, rather the wearing of any head covering which would conceal the wearer's identity. Given that the measures taken by Romanovia, passing the Mavazi ban, were not proportionate to the aims they were pursuing, unlike
there were evidence that the people who wore the Mavazi were disproportionately likely to commit terrorist attacks. Would that mean that it was a proportionate response to the terrorism threat? Assuming that that was in fact the aim, and I know that you're disputing whether it was the aim, but would that be if there were evidence of that?
No, Your Excellency. Amlania would contend that that is not considered a legitimate aim due to the fact that banning the wearing of the Mavazi violates not only their religious rights, but also their cultural freedoms, which are protected by the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights as well.
It should understand that you're making the argument that the purpose behind the enactment of this provision was public safety, but under the test set out for Article 18, there could be other purposes too, can't there, such as protection of fundamental freedoms. Isn't that right?
Yes, Your Excellency.
And so couldn't they have enacted this provision to further the fundamental freedoms of women in Andalusia?
No, Your Excellency. Discrimination against women violates both the principles of gender equality and of respect for human dignity.
How is wearing a headscarf discrimination?
Your Excellency, the wearing of the headscarf isn't discrimination. Preventing the Elysian women the opportunity from pursuing the development of their culture is the way that the Mavazi ban discriminates against them.
Suppose that the culture is oppressive, and I realize that's a very inflammatory thing to say, perhaps. But consider the example of genital mutilation, right? Which is a cultural practice in some parts of the world. Suppose that there were a ban on that practice, and the ban was challenged before this court on the ground that it interfered with the religious freedom and religious practices of the people. How is this a different type of situation? Because the women who are wearing this may not be wearing it of their own full volition. They may be wearing it because they're told that they have to wear it by their parents because they may suffer some sort of harm if they don't wear it.
Your Excellency, women would be protected from mutilations under Article 7 of the ICCPR, which prevents inhumane treatments. However, none of the practices at issue this evening are considered inhumane, nor is that at issue before the court. The International Covenant on Economic, Social, and Cultural Rights states that all people have the right to freely pursue the development of their culture. Article 5, paragraph 1 explicitly states that no acts can be aimed at limiting this pursuit. The ban passed by Romanovia is aimed at limiting the pursuit of Elysian culture.
which clearly violates Article 5. Article 15 then states that every individual has the right to participate in cultural life. States must take steps to promote the development and the diffusion of culture. Allegiants have occupied the territory comprising Ambulania's southern provinces and Romanovia's northern provinces since prehistory. Their cultural practices outdate the formation of Romanovia, and Romanovia should not be allowed to enact laws that impede the development of their culture, directly conflicting with Article 15 of the ICESCR.
So, I assume there's a national security exception as well to restrictions on cultural expressions.
Yes, Your Excellency.
And why isn't that satisfied here?
Your Excellency, or Mr. President, that is not satisfied because the ZDP is not a threat to Romanovia's national security. The Allegiants only occupy the northern provinces of Romanovia, and they only acted in response to President Kutai's dislike of the ZDP, which was expressed in his statements referring to them as barbaric and backward mentally.
Well, that, I mean, he is the chief executive, right? He's not the legislature which enacted the law. So how did he, what evidence is there of the motivation of the legislature into the promulgation?
Your Excellency, moving back to the second factor necessary to determine whether or not a restriction on religious freedom is necessary, it must pursue a legitimate aim. The Mbazi ban is not aimed at the ZDP, who are the ones attacking Romanovia. It's aimed at Elysian women.
Do we have any evidence about what the motivation was? Were there debates? I may not be totally familiar with the compromise, so I'm asking you if there is any evidence of what the motivation was for the legislature that enacted it.
Your Excellency, the compromise is silent as to any discussions that took place. However, President Kutai began pushing the Mbazi ban through Parliament due to the ZDP's separatist movement, which he disagreed with. Given that women have fewer rights in Elysian society due to the fact that they are prohibited from doing certain things as a cultural tradition, the ZDP would be comprised mostly of men. Therefore, the Mbazi ban does not hinder the efforts of the ZDP in any way, given that it wouldn't affect any of its members. However, Elysian women alone feel the full effects of the ban. Therefore, because the ban is incorrectly aimed at Elysian women and not the ZDP, it does not meet the requirement established by the courts and should be held to violate international law. The second way that the Mbazi ban violates international law is that it causes discrimination against women. According to the Convention on the Elimination of All Forms of Discrimination Against Women, which Romanovia is a party to, discrimination against women includes restrictions that impair the exercise of fundamental freedoms, including but not limited to cultural freedom. The Mbazi ban impairs the Elysian women's pursuit of their cultural development, because it restricts women, not men, from wearing the Mbazi, because the Mbazi doesn't apply to men.
Was it a man or a woman who was the perpetrator of the terrorist attack that led to the passage of this legislation?
Your Excellency, the identity of the individual who attacked the Romanovian buildings is unknown.
But in any event, that person was wearing a Mbazi headscarf, no?
Yes, Your Excellency.
So is presumably a man or a woman could conceal their identity using this headscarf and perpetrate some act of violence, no?
Yes, Your Excellency.
And doesn't that undercut your argument that there's no national security purpose that justifies this bill?
No, Your Excellency. If the bill was aimed at promoting public safety, it should have been structured so that it prohibited the wearing of any type of head covering, not the Mbazi exclusively. Any type of head covering that would conceal the wearer's identity. This discriminates against solely the Elysian people. The Mbazi ban impairs the Elysian women's ability to exercise their cultural freedom. Your Excellencies, I see that my time has expired. May I please have a brief moment to conclude? In conclusion, Ambulania requests that the court order Romanovia to immediately repeal its Mbazi ban because it has violated multiple principles of international law by allowing discrimination against Elysian women and children, as well as discrimination against the Elysian culture, and it unnecessarily limits the Alesians' religious freedoms. Thank you. Good evening, Mr. President, Your Excellencies. May it please the Court, my name is Whitney Johnson and I represent the state of Romanovia, the respondent in this case. There are two issues before the Court tonight. The first issue is whether the Court lacks jurisdiction over Anne Delania's claim. The second issue is whether the limited ban on the Mavazi is in violation of international law. My co-agent, Ms. Naila Alam, will be addressing the second issue tonight. First, Your Excellencies, to find that this Court has jurisdiction over Anne Delania's claims is to undermine the Charter of the United Nations as well as the Statute of the International Court of Justice. It is to question the integrity of the Security Council, and it is to create confusion within the international legal community. For these reasons, Your Excellencies, Romanovia respectfully requests that this Court adjudge and declare that it lacks jurisdiction over Anne Delania's claims because, first, Anne Delania has not applied to membership of the UN in its own right, thus is not a party to the statute. Second, Anne Delania is not the proper successor state of the former Paula. And third, in the alternative, Anne Delania lacks standing to bring a claim on behalf of the Alesian people. First, Article 35 of the Statute of the International Court of Justice provides that the Court is open to all states party to the present statute. Article 93 of the Charter then supplements this in stating that all members of the UN are ipso facto parties to the statute. As provided in Nicaragua versus the United States, it is provided that to become a party to the statute, a state must first declare its intent to be bound, and second, accomplish the indispensable step of sending its instrument of ratification to the Security General.
Hasn't that already been accomplished if Anne Delania claims it's the successor state to Paula? Paula was a member of this court. What more need they do?
Your Excellency, Romanovia contends that the note of continuance as provided in paragraph 6 of the compromise is simply a unilateral statement declaring its intent to be bound. It is not an instrument of ratification.
Well, but unilateral statements issued is can bind the state.
Correct, Your Excellency. However, as provided in Chapter 16, Article 103 of the Charter, the Charter trumps all treaties and customary international law general principles, and thus, under customary international law as a unilateral intent to be bound, the steps implemented as in providing whether a state is a member of the UN, thus a party to the statute, would trump that of customary international law.
So even if there is a technical deficiency in their seeking to be the successor state, so suppose that we conclude that, we also have the power to act in equitable fashion. So this seems like a situation where if there's no other nation that will bring this claim on behalf of these people, only nations are allowed to bring claims before this court, then we should recognize, at least for purposes of this case, that there is, they have jurisdiction, we have jurisdiction over this case, because no one else will bring a claim if they don't. And if we dismiss on the jurisdiction question, they will just apply for membership, they'll get membership, and we'll be right back where we started.
No, Your Excellency, to address the issue of no one else bringing a claim on behalf of the Alesian people, Anne Delania cannot bring the claim if the court finds that it does have jurisdiction, as Anne Delania lacks standing to bring the claim on behalf of the Alesians per Article 7 of the Draft Articles of Diplomatic Protection and Article 14 of the Draft Articles, which state that Article 7 states that a state cannot bring a claim on behalf of an individual who is also a nationality of the injuring state if the person injured is also a member of both states, thus the dual citizenship as we have here. The only way that Angelini can bring the claim is if it is the predominant nationality of the Alasian people. Angelini is not the predominant nationality of the Alasians, as provided in paragraph 15 of the compromise, which states that 75% of the ZDP, or Alasian Democratic Party, are Romanovian Alasians. Additionally, Romanovia encompasses a majority of the landmass and a majority of the overall population. Thus, it can reasonably be inferred that the Alasian people are majority Romanovian Alasians.
To we agree with you that we have no jurisdiction to the Article 4 issue, and that Lithuania is not the successor state of Pala. It seems like a strong argument. Isn't it true that at that point they could not simply reapply for membership because you entered into a reservation when you accepted the jurisdiction of the ICJ that would not accept jurisdiction over any case in which a member state sues who's been a member less than 12 months? Is that correct?
Correct, Your Excellency.
And so does that mean that there would be effectively no remedy for this group of individuals who are harmed?
No, Your Excellency. Although the compromise is silent as to the procedures that the Alasians had taken, reasonable inferences can conclude that the Alasians did not exhaust their local remedies as is necessary under the diplomatic protection, Article 14 on diplomatic protection.
What would these local remedies consist in?
The Alasians could have brought a claim in the Romanovian courts. It could have been a civil claim against the president if it was the comments of the president that are the alleged injury of the Alasians.
Well, the injury is the statute, of course,
Mm-hmm.
and the enforcement of the statute. Could they have brought a claim to challenge that in the Constitutional Court of Romania?
Yes, Your Excellency. And until they exercise that remedy, Angelini or any other state cannot bring a claim in this court.
Agent Johnson, getting back to the question of successor state. The other agent mentioned the Nicaragua case, which suggested that this court does not have a history of being extremely persnickety about the rules that you think under Article 103 trump customary international law. How do you distinguish this case from Nicaragua?
Your Excellency, Mr. President, in the Nicaragua case, it is actually contended that Nicaragua did fulfill the proper steps. However, facts pertinent to that case with the war going on at that time provided that Nicaragua could not fulfill the two steps. Nicaragua claimed that they did actually ratify and deposit their instruments. However, it was lost in the mail as they contend. Thus, Angelini has never even had an intention or had any indication of intent to ratify.
But isn't there a bait and switch going on here? Because they, at least the understanding, or there was some communication, some confusion of communication going on here, where they were led to believe, arguably, I'm sure you will argue against, they were led to believe that they could be the successor state and that the United Nations would recognize them as the successor state, so they did not take the steps necessary to move forward with their own membership. And so wouldn't it be unfair, wouldn't it be unjust for us to deny them what they arguably have been promised?
No, Your Excellency, because as of the time that they issued their note of continuance, the UN Security Council stated that they could not continue the membership. The Undersecretary General provided that they could not continue the membership, however, they did have a temporary allotment of time. This is analogous to the case concerning the legality of the use of force, in which the FRY, which was formed by Serbia and Montenegro, issued a note of continuance of former Yugoslavia, and the court determined in that case that it did not have jurisdiction because the Security Council issued Resolution 777 stating that the FRY should apply for membership in its own right. Thus, Angelini should have known that they would not be able to be a member until they applied in their own right.
Since that time, everyone has treated them as if they were a member. They've cashed their checks on behalf of the former country of Paula. So aren't they correct in assuming that they are a member if all other nations are treating them as a member and they are allowed to participate as a member?
No, Your Excellency, because also provided in the case concerning the use of legality of force, the FRY also paid the dues of former Yugoslavia. The flag was flown, they sat behind the nameplate, and still the court found that it was not a member until it applied in its own right. Additionally, the compromise is silent as to the actual participate. Your Excellency, I see my time is up. May I please briefly finish answering your question? The compromise is silent as to whether they actually participated in the General Assembly. Thus, one can reasonably infer that they simply sat behind the nameplate, as did the FRY, and were not a member and will not be a member until they apply in their own right. Based on the foregoing arguments, Your Excellencies, Romanovia respectfully requests that this court adjudge and declare that it first does not have jurisdiction over Ambulania's claims, as Ambulania has not accepted the jurisdiction of the court in its own right. Is not the proper continuation of former Paula, and in the alternative, it lacks standing to bring a claim on behalf of the Alations. My co-agent will now address the second issue regarding the legality of the use of the Mavazi. Thank you.
May it please the court. Good evening, Mr. President, Your Excellencies. My name is Nyla Alam, and I represent the state of Romanovia, the respondent in the case before this court. The next issue in this case is whether or not this court should determine that the Mavazi ban does not breach international law, since it is in compliance with its international obligations. Your Excellencies should keep in mind that this is a case concerning the Romanovian government's ability to effectively protect the public safety and public health of its citizens, in addition to guaranteeing their rights that are given to them under international law. This court should not order Romanovia to repeal its Mavazi ban, since it is prescribed by law, it is in pursuit of legitimate aims set out in Article 18, Paragraph 3 of the ICCPR, and is necessary to protect the rights of the general public, including Romanovian women. First, Your Excellencies, this ban is in pursuit of legitimate aims set out in Article 18, Paragraph 3 of the International Covenant on Civil and Political Rights, which states that limitations to expressing freedom of religion shall be subject to governmental objectives such as public safety, public order, and maintaining the public health of its citizens.
Agent, can you tell me how the banning of a headdress or headwear of any type is going to prevent any type of violent act?
Your Excellency, per paragraph 14 through 18 of the compromise, it states that the Mavazi was used to incite violence in public buildings such as 2 government buildings and destroying a bridge, killing and injuring more than 300 Romanovians, some of whom could have been Alesians. This perpetrator was able to escape governmental detection and law enforcement because he or she was concealed by wearing the Mavazi.
Is there something special about the Mavazi that allows someone to be particularly hidden? Why not just impose a ban on all headdresses or anything that would obscure the person's identity?
Your Excellency, the Human Rights Committee, in its General Comment 22, has stated requirements for limitations per paragraph that are enacted under paragraph 3 of the Article 18. The first requirement is that these limitations should be proportionate and directly related to the aim that they are sought. In narrowly tailoring the Mavazi ban, the Romanovian government has targeted the Mavazi because the evidence has specifically pointed to the fact that it was the Mavazi that was used and no other head covering that was used to escape detection of law enforcement.
But this bill was introduced, this ban on the Mavazi was introduced before any of these public safety issues even occurred. I mean, how can you reconcile that?
Your Excellency, it was also passed right after the attacks And in attempt to prevent any further disruption of the public safety that these citizens have faced, the Mavazi ban is in pursuit of these legitimate aims.
But I mean, is your president clairvoyant? I mean, he introduced this bill before any of these bombings happened. It sounds like you're using these bombings to justify something that might have just been purely discriminatory on his part.
Your Excellency, per paragraph 15 of the compromise, it states that the ZDP represents 75% of Romanovian Alesians who reside in Romanovia. This indicates that even though that perpetrator has escaped, there's nothing to stop the rest of the 75% of ZDPs in Romanovia to use the Mavazi to destroy another public building.
Agent, on a slippery slope question, where do you draw the line? What happens to umbrellas from now on? If somebody uses an umbrella to conceal their identity in the rain and something happens, where do you draw the line?
Your Excellency, the Mavazi is made of a thick deer skin hide. This effectively conceals the perpetrator's identity. An umbrella does not have the same effect. In addition, Your Excellency, several cases indicate that a ban that is similar to the Mavazi has been upheld because it does, the government has stated the legitimate aims of Article 18, Paragraph 3 of the ICCPR.
So the other examples I'm thinking of have to do with wearing religious garb. For example, when you're a public school teacher, and it may send mixed messages, or in other contexts where the religious symbolism is the problem and not the covering. If I were a terrorist, after this ban were enacted, I would go out and buy a ski mask, and then go out and conduct my terrorist attacks, because this is an under-inclusive ban. Because if that is the aim that you have with this ban, then it's not going to accomplish that.
Your Excellencies, then the other legitimate aim of this ban is to protect the rights of the Romanovian public, including Alesian women. Per the ICESCR, the International Covenant on the Economic, Social, and Cultural Rights, parties that are to the present covenant take the obligation to make sure that all women and men in their country can enjoy their economic, social, and cultural rights. This court should recall that these economic, social, and political rights are properly enjoyed in the public sphere. These attacks that were carried out in public have interfered with all Romanovians' rights to enjoyment of these rights.
So you're saying that you had to take away the rights of these women in order to save the rights of other women?
Your Excellencies, we are actually putting them on equal footing with all other Romanovians. This Mavazi comes with the cultural practices of confining women to their home, preventing them from gaining employment, getting paid for their employment.
Those practices, in other words, why not prohibit or enact legislation that requires equal rights for women as opposed to banning that type of, or regulating the type of head garb that they can wear?
Your Excellency, the Mavazi comes with the implication that these women are not able to gain any type of education. By eliminating the Mavazi, it allows the women to feel that they can go out in the public sphere and gain their education.
But how do we know that? I mean, I don't see any evidence on the record that this is something Mavazi wearing women want. I mean, how do we know that they don't want to wear the headdress? That's a right that they want to hold and not get rid of.
Your Excellency, this is a limited ban. It does allow the women to wear the Mavazi in private places and while conducting private activities. The two aims that have been the two purposes of this ban are to ensure the public safety of our citizens and to guarantee everyone's rights. But the Mavazi, by removing the Mavazi, it gives Alesian women who do not want to wear the Mavazi the chance to make the choice for themselves.
But it also removes the rights of women who do want to wear the Mavazi to wear it in public.
Your Excellency, that goes to the fact that the Romanovian government does have a legitimate interest in protecting the public safety and the public health of all Romanovians. Since the Mavazi has been used to incite the acts of violence, the public no longer has to be afraid that the Mavazi will be used for attacks in public. In addition, Your Excellency, Article 3 of the International Covenant on Economic and Social and Cultural Rights states that the Mavazi states that governments have the right to ensure that legislative measures will modify social and cultural patterns to make sure that cultural patterns that are based on stereotypical roles of women will be eliminated to give them a chance to participate in their economic rights.
It sounds somewhat paternalistic to me to tell these women what is best for them, based on some idea that we as judges have, as cosmopolitans, or some idea that international jurists have. But why don't they have the right and the ability to choose for themselves what is most powerful?
Your Excellency, by removing the Mavazi, it eliminates the way that these women have been forced to stay at home. This allows them to exactly have the choice to decide for themselves whether or not they want to pursue these rights that are guaranteed to them under international law.
I'm sure that the argument would be made by some Mavazi women that it is liberating to where they are free from some of the sorts of harassment that women encounter on the street every day, for example, when they're hidden. And these reasons why in many countries around the world, women wear various means of disclosing hiding their identity, right? Because they don't want people to be gawking at them. For example, why is that not a liberating? I don't feel like the values that you're talking about bend all in one direction.
Your Excellency, I see that my time has expired. May I briefly answer the question? Can you please rephrase the question?
Isn't it also liberating for these women to be able to wear this in furthering values that you're talking about? Freedom of expression, freedom to go outside and not be like women are in many places, in many countries, harassed.
Your Excellency, while that is liberating, not all Elysian women will feel that the Mavazi is a liberating aspect of their culture. And so, Your Excellencies, in conclusion, Romanovia respectfully asks that this court adjudge and declare not only that the applicant not have standing, but that the Mavazi ban does not breach international law, since it is in compliance with the International Covenant on Civil and Political Rights, Article 18, Paragraph 3. Thank you.
Agents, do you have rebuttal? Okay.
All rise. The Honorable Court is now adjourned. The judges will now deliberate. Y'all may be seated.
Before the judges present the Best Advocate Award, we'd also like to, you all may sit by the way. We'd like to present the Best Memorial Award for this year, and that goes to Miss Julie Johnson.
Right, so the four of you did not make our task at all easy. You were all very strong, and we commend you all. But we've made our decision and decided that Blurred Lines is the song of the summer. say to all of you about your presentations and a few notes for each of you, but we agreed that the best oral list was with